Hi, everybody. Michelle Conti here with Conti Law. What happens when a minor child is the beneficiary of an estate? Once the estate is settled and the funds are ready to be dispersed to the beneficiaries, if a remainder trust has not been created in the decedent's will and the minor child is simply named, then we have to petition the court for a limited guardian to serve on behalf of that minor until they turn 18. Or if they live out of state, whatever the age of majority is in that state. It cannot be the biological parent, so oftentimes the court will appoint a third-party fiduciary to serve in that role as limited guardian, and most often it is the attorney of record. There are very specific rules that must be followed, and the account that the funds must be held in have to be overseen by the court, and they can only be used once we obtain court's permission. So whether that's for the child's health, education, or support, we will petition the court each time we need to pull funds from that special minor's account. And then when they turn 18, those funds can be turned over directly to the minor who has now reached the age of majority. I always tell people, if you're leaving something to a child who's underage or a grandchild, we want to make sure in your will that you have the specific language of a remainder trust and appoint a trustee that you trust to serve in that role to manage and marshal those assets until that child has turned either 18 or a specific age of your choosing. Now, if you die without a will in Pennsylvania, then the court will appoint a third party to serve as limited guardian until that person has attained the age of 18.